There's no distinction between commercial and residential property over here. There's a couple of other distinctions that we need to have a look at when it applies or when it does not apply. I know there has been so much speculation and so much discussion regarding CPA in the property market of people saying, but it will not apply because of this, and then it does not apply because of this and everything. And the majority of the arguments on this would be the whole thing of in the ordinary course of business. Probably heard that discussion previously, because in terms of the CPA, the definition of supplier or landlord, we can call it that, is a person who, in the ordinary course of business, does transaction. I'm here to tell you, just in the Kerr textbook as well, with court cases, if you're renting out a property for investment, like you're getting tenants into your property, what is that? That's the ordinary course of business of that property, isn't it? Same in tax legislation. They've also got a very similar provision regarding ordinary course of business. It's going to be exactly the same. First thing you have a look at, if it's going to apply or not apply, is your lease agreement must be for a fixed term. What's a fixed term contract? It's got a specific start date and it's got a specific termination date. Is a month-to-month lease agreement a fixed term contract? No. Good. Can all agree to that. It's a month-to-month lease agreement. It doesn't have a fixed term. The second thing you have a look at, and here's the kicker, because people have written into their lease agreements things like the juristic person's annual turnover or asset value over or under 2 million. We've all seen those most probably in lease agreements. It has no effect in terms of section 14. Absolutely none. The reason why I say this is it says regardless of annual turnover, asset value. So you don't take that into consideration at all when having a look at this. The only other thing you need to consider is who are the parties, who are the contracting parties, so your landlord and your tenant. In terms of strict interpretation, this section does not apply to transactions between juristic persons, regardless of asset value or annual turnover. So your landlord and your tenant must be a juristic person. What's a juristic person? Closed corporation, Pty limited, trust, partnership, body corporate. So they've extended the definition in terms of the CPA to include a couple of others. It will only be in circumstances where both your landlord and your tenant are not juristic entities. First things first, in terms of the CPA, a tenant may at any time during the contract period give the landlord 20 business days notice to terminate the contract. Anytime. So it's not a calendar month, 20 days or whatever it might be, it's 20 business days notice. And then they can cancel the lease agreement. The landlord can, however, hold them liable for something called a reasonable cancellation penalty. Now, what's a reasonable cancellation penalty? I'm going to ask you that. How many months rental? 1, 2, 3. So usually between 1 and 3 months that you would be able to charge. I've seen very few circumstances where you can charge more than the actual 3 months cancellation. There's another thing you have to look at regarding the actual penalty that you would be able to charge. It's called the Conventional Penalties Act. Now the Conventional Penalties Act states that I can't charge more damages than actually suffered by a party. So if you're only suffering 1 month's damages, you won't be able to charge 2 months cancellation penalty. You'll only be able to charge that 1 month. Similarly, say now for instance the tenant cancels the lease agreement, vacates the property, and you find another tenant directly thereafter. So you've suffered actually no damages. Would you be able to claim anything from the tenant? Simple as that. Good. You won't be able to. It's possible that you would be able to claim lost commission, but I'm going to get into that when you do the whole estate agency affairs board situation, okay? So if it's in your contract, it would be possible to go and claim something like lost commission. But for any other damages, anything like that, holding over damages, you can't charge anything in that regard. Second thing, how many days notice will a landlord have to give the tenant if he breaches the contract? 20 business days notice. It's a very long period, isn't it? Usually you had this like 7 calendar day notice type thing, letter of demand for 7 days, and then you could cancel the lease agreement. Unfortunately, it's now 20 business days if the CPA applies. How do you count business days? Now, I know this sounds incredibly stupid, but attorneys count strange. we use something called LIFO, last in, first out. So what that means is, I may technically send a letter of demand when? Second. I can send that letter of demand. The second does not get counted as a day because it's the first day, last in, first out. So you don't count the second. You only start counting from the third. And then you've got to give the person the full 20 business days, and you can only cancel on the 21st business day thereafter. So for instance, say now my 20th business day is a Friday. When will I be able to cancel the lease agreement? On the Monday. Excellent. Please count your days 13 times over if you have to. Don't cancel the lease agreement early. It's called repudiation, and it's terrible. And then you pay the tenant damages as a result of the repudiation, even though they're in breach. So please keep that in mind. Go and count the days. If you need assistance with that, contact us and we'll help you figure out exactly when you can cancel the contract. With something like this as well, cancelling the contract and how you cancel, we'll go through that when we go through evictions, and I'll show you exactly what to do. But the contract is not automatically terminated, correct? Or automatically cancelled after the 20 business days. You need to send out another letter called a letter of cancellation. But we'll go through that in more detail when we go through the section on evictions. The third important thing. Now, this is one that very few people get right, and I get questions about this almost every single day. Let me ask this. Who's got in their lease agreement that the tenant needs to give the landlord notice a month before the termination date whether they'd like to renew or not? Lots of people. I'm here to tell you that you're as wrong as a GPS in Cape Town. It's not the correct way of doing things. In terms of Section 14 of the CPA, the landlord or the agent must give the tenant notice 40 to 80 business days prior to the termination date of the contract, whether the landlord would like to renew the lease agreement, what the new material terms are, and if they would not like to renew, the contract terminates on a certain date. Then the tenant has the opportunity to get back to you and say, listen, yeah, I'd like to renew on the material terms, I'd like to renew on these new contract period. But the landlord needs to send the tenant notice. If you don't do this, and the tenant just vacates on the termination date without letting anybody know, could you hold them liable? Not at all. This notice is also not a new lease agreement. It's just a notice, something that the landlord sends out. If the tenant says, yes, I'd like to renew, what do you need to do? New renewal addendum, new contract, or a new lease agreement. Also, another question that we get on this is, specifically on renewals, what should I do? Who does renewal addendums? Who does new lease agreements every single time? Are any of you incorrect? No, not at all. It's a personal preference. What I would just suggest is that you do one lease agreement, one renewal. One lease agreement, one renewal addendum. One lease agreement, one renewal addendum. The reason for this is, you saw now how many pieces of legislation are changing. And if our lease agreements have been amended to include certain provisions to assist you, you want the new lease agreement to be applicable. It will anyway if the legislation changes, but you don't want to be left in the dark with the old lease agreement that's still got like stamp duty on it or something. So go and do a new contract or go and do a renewal addendum, but I'd rather just do one renewal addendum in this regard. There are a lot of other questions regarding the CPA, not necessarily dealing with Section 14. Who's heard about the term direct marketing before, or cooling off period? The CPA specifically states that if a property is marketed, not a property, but a product is marketed in a way that is considered direct marketing, the tenant has 5 business days to cancel the contract after signature. Now, what's direct marketing? It's literally, use this example, okay? I am standing in Woolworths. I am the best Oracle estate agent in the whole entire world. I can see tenants. I can see good tenants. I know them. I can see them in Woolies. So I would go up to a person in Woolies and say, listen here, you look like a great tenant. I've got a fantastic property for you. That's direct marketing. That's direct to one person. If you're placing things up on ads or whatever it might be, you're marketing to who? General public. If you're cold calling somebody, however, direct marketing.